Parliament has a maximum of 60 days within which to enact the two-thirds Gender Rule Amendment Bill of 2015.
High Court Judge Justice John Mativo ruled that the National Assembly and the Senate have failed in both their joint and separate constitutional obligations to ensure that the principle of gender representation as enshrined in the Constitution is protected.
Here's Sharon Momanyi with more details.
Note of Madam must be and is thereby issued directing Parliament and the Honourable Attorney General to take steps to ensure that the required legislation is enacted within a period of 60 days from the date of this order and to report the progress to the Chief Justice.
It is this ruling by Justice John Mativo Wednesday morning that could possibly see a fast-tracked implementation of the two-third gender rule. In the ruling, the judge stated that Parliament failed to fulfill its fundamental role by failing to enact the law on the two-thirds gender rule as required by the Constitution.
I am satisfied that the first and second respondents have failed, refused, and or neglected to perform their constitutional mandate prescribed in the Constitution. Consequently, this petition succeeds.
Petitioners in the case, including the Center for Rights Education and Awareness, Community Advocacy and Awareness Trust, and the Kenya National Commission on Human Rights, described the ruling as a big win for Kenya as it seeks to attain gender equality, including in elective posts.
One of the things he said today is there is nothing like the supremacy of Parliament. Parliament has acted contrary to the will of the people, contrary to the Constitution, contrary to the rights of women in this country.
Na kwa hivyo tungeomba ya kwamba wanasheria wote watuunge mkono, washikane na sisi kama kina mama, ya kwamba wapitishe bili ya kwamba tukue 50-50 kwa bunge.
The gender rule would require that at least 117 out of the 349 seats in the National Assembly be occupied by the lesser represented gender. As it is, women in the current scenario, should 117 women not be elected, political parties would have to nominate them to add up to the required proportion. Those opposed to this say that this would lead to a bloated parliament.
The bloating will only come about if there is a lack of political will. Political parties are essentially the primary gatekeepers of those seats, okay? They can put within their own political party systems, mechanisms to ensure that women get elected.
Justice Mativo further gave the green light to commence the process of dissolving Parliament should it fail to meet the 60-day deadline.
That a failure by Parliament to enact the legislation contemplated under Article 27(6) and 8 and 81B of the Constitution amounts to a violation of the rights of women to equality and freedom from discrimination and a violation of the Constitution.
The letter advising the President to dissolve Parliament should be ready by 29th of May. But we don't want to get there. We are hoping that something will happen that will not get to dissolution of Parliament, that we shall not disrupt the activities towards the election, because when we have a dissolution of Parliament, then the timelines for the election must change.
Following an advisory request by the Attorney General, the Supreme Court made a majority ruling in December 2012 that a framework to implement the two-thirds gender principle must be in place by August of 2015. Parliament extended this period by a year, further failing to pass the bill twice, including by boycotting the vote.
7 years after Kenyans passed the new constitution, and they are finally staring at a possibility of seeing public offices constituted as prescribed by this document with regard to gender representation. 60 days is what Parliament has to uphold this ruling or be totally dissolved. Sharon Momanyi, KTN News at the Milimani Courts, Nairobi.
Right, so Parliament has been found guilty, and Alicia Ongoya, who has been with us this evening on the broadcast, was representing two of the petitioners in that case, that Center for Rights Education and Awareness crew, as well as Crown Trust. Alicia, so let's talk more about this ruling. And one of the things we have had, of course, has been a long journey coming up to this particular point. But on one hand, with the law requiring that elective and appointive positions, at least not more than two-thirds of each gender take them up, there are arguments that when you're talking about about appointive positions, it's understandably relatively easier to achieve. But elective, the chips fall where they may. So is it an unreasonable requirement? Did we fall short in terms of this particular requirement?
I'm a constitutional law practitioner, and I'm also a constitutional law scholar.
Right.
And where we are now, the question whether or not it's reasonable or unreasonable is a question whose debate ended on 4th of August 2010, when Kenyans were debating what to approve, what not to approve. What is sure to my mind is that at the end of the day, Kenyans approved the principle in Article 27, Sub-Article 8 of the Constitution, which prescribes that the government shall take measures, including legislative, policy, and other measures, to implement the principle that not more than 2/3 of members of elective and appointive public bodies shall be of the same gender.
Right.
So the Constitution dictates it, and it applies the principle to elective offices.
All right.
Article 81, paragraph B of the Constitution also provides one of the principles that govern our electoral system. One of those principles is that not more than 2/3 of the members of elective public bodies shall be of the same gender. And therefore, speaking as a constitutionalist, the Constitution gives very many promises to us. You in the media industry keep citing Article 34, media freedom. And you'll keep telling us, it's not for us to keep saying this media freedom is unreasonable. And just the same way you expect that because the Constitution guarantees you media freedom under Article 34,
Right.
the various sexes also expect that the promise given to them in Article 27, Sub-Article 8,
Right.
and Article 81B shall equally be given effect to.
So,
now,
yeah.
let me conclude by saying the task of implementing the Constitution has never been easy. And therefore, if you are elected president, you are elected member of the National Assembly, you are elected member of Senate, it is not open to you to say that this question is too complex.
Okay.
We never elected you to discharge simple responsibilities.
So then do you think, from where you sit, that Kenyan parliamentarians, especially perhaps the male or even the women, do not want women, because in this case they're the disadvantaged group, to get into these positions, whether elective or appointive? Or is it a difficulty with the proposals you've been able to hear about in finding that mechanism that will work?
As I made my submissions in this case, I submitted that there are 4 key pillars to realizing transformative constitutionalism. A constitutional process that changes our way of doing things as a society. One is that you must design the constitution well. And I think our constitution was fairly well designed. Number 2, you must have an independent judiciary, a judiciary that is committed to pronounce itself on the Constitution without fear or favor.
Right.
Number 3, you must have a vigilant citizenship, people who are on the lookout for breaches. And number 4, you must have political will. What I think has been most deficient in this makeup is political will. Let me give you an example. It was much harder to remove members of an independent constitutional commission from office as we did with the IEBC commission. But we did it with ease, without shedding blood. It is easier to implement the 2/3 gender principle than to remove IEBC commissioners from office. And therefore that means where there is political commitment to do something, we will do it.
So there's 60 days ultimatum that has been given by the judge. However, it falls around the same time the life of this parliament will be coming to an end. Yes. So there are those who argue this is a clever ruling. It just, will not put any form or sense of urgency on the members to be able to implement, and that this matter we can now safely say will fall perhaps in the purview of the next parliament.
Again, let me tell you something about transformative constitutionalism. It is such that we also must have a culture of good manners, a culture of respect for legal principles, a culture of respect of institutions. Like when a court has pronounced itself, we must have a culture of giving effect to it. And therefore, I do not think that our Constitution anticipated a mischievous parliament. It anticipated a responsible institution called Parliament, which once guided as has been done by the court, will take it in stride, unless, of course, it opts for other remedies available in law like appeal. It will take the ruling in stride and use the ruling as a guide to move this country to the next level. We have been at this level of the debate for too long. But if Parliament does not give effect to it, the Constitution in Article 261 prescribes the remedy. In fact, the judge did nothing novel. The judge just read out what Article 261 says, that then the Chief Justice will advise the President to dissolve Parliament, and the President has an obligation to dissolve Parliament.
Yeah.
That guillotine clause was put there to provide some sense of danger.
So you're hoping there's goodwill, although there isn't danger because their term is coming to an end anyway.
You know, these members of Parliament are struggling to have their pay kept up to March next year.
Okay.
If you told them you are cutting their term by 2 months, the same instinct may prompt them to do something about it.
All right. All right. Many thanks, Elisha Ongoya, who is an advocate of the High Court as well as outgoing Dean Kabarak University Law School with us tonight here on KTN Prime. Ben.